So here we go, guys. We are now going to do our coverage of who is more free, New Zealand. The thing about New Zealand is that their constitution isn't a straight shot, much like the American, Canadian, or Japanese constitutions are. New Zealand's history is rather checkered, and a lot of their rights and guarantees as human rights and legal privileges and all that stuff, they're a lot more disjointed and strangely convoluted. And the Constitution that they do have is the summation of events that led up to it, starting with the Declaration of Independence written in Maori, signed by one James Busby, a British colonist, and 34 Maori chiefs. Now, unbeknownst to the Maori, this actually signed New Zealand over to the British Crown as a British colony. But 4 years later, February 6, 1840, the signing of the Treaty of Waitangi was achieved. Now, this, of course, was an agreement between the Maori and the British Crown, basically guaranteeing them all rights of British citizens. And they were ruled basically as a British colony up until 1947 when they achieved independence. And it wasn't here, it says, until 1979, they had a cabinet manual that basically instructs the government on how to function, how to make decisions. And then it was in 1982 that they had the Official Information Act, which talked about freedom of information and government transparency. As you can see, this was a bit of a learning process for them, so these things came in increments. A lot like what the U.S. Constitution did, but it was a little bit more messy given that, the distance between New Zealand and Britain and everything that went along with that. And following that, there was 1983. It was the letters patenting constituting the office of the Governor General of New Zealand. Describes the role of the Governor General and function of Executive Council. Okay, so they started going into the executive branch more on that. The Constitution Act of 1986, and it describes three branches of government. Replaced the New Zealand Constitution Act of 1852. All right. So this was the next step in the constitutional law of New Zealand, basically. And then you had the Imperial Laws Application Act of 1988. And that basically incorporated British constitutional statutes into the New Zealand law, which included Magna Carta, the Bill of Rights of 1689, and the Act of Settlement of 1701. A lot of these were part of the British colonization efforts and the British Crown's desires and all that. Now we have, and this is the New Zealand Bill of Rights Act of 1990, and that's what we're going to be primarily going over moving forward after these next couple of pieces of their history. And then you had the Electoral Act of 1993, which describes the election of the members of Parliament. Okay, so their Parliament, the set of elections of Parliament didn't happen until 1993. Wow, that's pretty recent. Ooh, here this is interesting. Seniors Court Act of 2016. It was just 5 years ago. It describes the jurisdiction of the New Zealand judiciary and constitutes New Zealand's senior courts, including the Supreme Court of New Zealand, as New Zealand's final court of appeal. So, a lot like the United States, the evolution. New Zealand is an evolution that's going on right now. They are rated, of course, number one, tied with Denmark for. On the UN's Global Corruption Index. So they are really, really, really good at keeping their government in check. And apparently, if anybody really remembers that interview that one New Zealand anchor did with that conservative politician that lost to Labour, I don't know if anybody remembers that, but she basically schooled him on what it means to be a public servant and like, no, you did this for yourself and you were scaring people and all this other stuff. It was great, man. If anybody looks that up, I highly recommend you try to find that because it was really good. But right now what we're going to do here, now that I've covered a little bit of that, is we're going to go to the New Zealand Bill of Rights. And here we go. Come on. Here we go. So, let's go and do a little bit of a read-through. Okay. Now, to be fair to everybody, I'm kind of reading off of Wikipedia here because the research process for New Zealand was a little difficult because their constitution is not a straight line. It's not just one straight document. It's a bunch of historical events and different treaties and court decisions, uh, ministry decisions of different provinces. It's just really convoluted. So we're going to do a little bit of read through here, starting with the application of the Bill of Rights. And they typically refer to the Bill of Rights Act of 1990 as the Act for short. So here we go. The Act applies only to acts done by the three branches of government, the legislature, executive, and judiciary of New Zealand, or by any person or body in the performance of any public function, power, or duty imposed by the law, which is Section 3. Section 4 specifically denies the act any supremacy over other legislation. Okay, so that's basically separation of powers. The section states that courts looking at causes under the Act cannot implicitly repeal or revoke or make invalid or ineffective or decline to apply any provision of any statute made by Parliament, whether before or after the Act was passed, because it is inconsistent with any provision of this Bill of Rights. Section 5 allows for justified limitations on the rights guaranteed by the Act, which are subject only to such reasonable limits prescribed by law as can be demonstrably justified in a free and democratic society. Sounds reasonable, right? Which is the same wording as contained in Canada's Charter of Rights and Freedoms. As a matter of fact, it is. And go back and look at my cover of the Canadian Bill of Rights. You'll find that. In July 2015, Taylor v. Attorney General, the Auckland High Court took the unprecedented step of issuing a formal declaration that an electoral law amendment stripping all prisoners of voting rights was an unjustifiable limit of Section 12A of the Bill of Rights. Whoa, hold on a minute. Let's read this before I comment on that. Section 6 ensures that where an interpretation of an act has a meaning that is consistent with the act, that meaning shall be preferred to any other meaning. Okay, so basically that's a supremacy clause, effectively, saying that whatever governors and ministers in their regions, provinces really, it's divided into 6 provinces, whatever those decisions may make, if the act, if it's in conflict with the act, the interpretation of the act will take precedent. So that's the supremacy clause. Now back to this one thing here. Electoral amendment, where is it? Okay, this is really interesting. The issuing a declaration that electoral law amendment stripping all prisoners of voting rights was an unjustifiable limit of Section 12A of the Bill of Rights. Basically, prisoners are allowed to vote in New Zealand. That's good, right? Everybody votes. Wonderful. Why don't we do that? Okay, Section 7 reports. Section 7 of the Act requires the Attorney General to draw to the attention of Parliament the introduction of any bill that is inconsistent with the Act. Okay, so basically they act as sort of a Supreme Court justice in this sense. They come before and say, whoa, wait a minute here. This doesn't match with the Act, so, you either change it or just kill it, whatever. The Ministry of Justice, which prepares this advice for the Attorney General, requires a minimum of 2 weeks to review the draft legislation. Okay, that's more than enough time. See the list. Okay, well that's nothing. Down to the good stuff here. Civil and political rights. All right, here we go. Part 2 of the Act covers all broad range of civil rights and political rights. Life and security of the person. As part of the right to life and security of the person, the Act guarantees everyone the right not to be deprived of life except in accordance with fundamental justice. Okay, in other words, due process of law. That's Section 8 of their Constitution, apparently. The right not to be subjected to torture or cruel punishment, degrading or disproportionately severe treatment or punishment, Section 9. The right not to be subjected to medical or scientific experimentation without consent, Section 10. Ooh, that's pretty interesting. I can't help but wonder if British colonists were actually doing that kind of thing to the Maori back in those days. Anytime you read someone else's constitution, you will tend to find some measures that are in response to what was going on at some point that the natives didn't like. or some people in another colony. In the case of the British Empire, didn't agree to or thought was inhumane and whatever. Continuing on here, the security person also has the right to refuse to undergo any medical treatment except in the case of involuntary commitment. Well, we kind of have that here too, except we have our healthcare system is for profit, which is a crime in and of itself. But if you think you can handle something on your own, okay, you can refuse medical treatment. That's fine. Democratic and civil rights, electoral rights. The Act sets out the electoral rights of New Zealanders. The Act guarantees that every New Zealand citizen who is of or over the age of 18 years has the right to vote in elections of members of Parliament, which shall be held by equal suffrage and by secret ballot, which is under 12A. Has the right to become a member of the House of Representatives, Section 12B. Furthermore, the Act guarantees everyone freedom of thought, conscience, and religion. Okay, no thought crimes. And you can think what you want, be what you want, whatever your religion. You're a free person. That's pretty straightforward. The right to the freedom of thought, conscience, religion, and belief, including the right to adopt and hold opinions without interference. Hold opinions without interference. Well, that's great. Wonderful. How come we think we have that in our Constitution, but really it's infringed all the time. There's no checks and balances on that, unfortunately. But the amendments I posted in my previous video hopefully would put a stop to something like that. Freedom of expression. The right to freedom of expression, including the freedom to seek, receive, and impart information and opinions of any kind in any form, Section 14. This also is a way of saying that they have freedom of speech. So in this sense, they actually do have free speech in New Zealand. Nice. Religion and belief. The right to manifest that person's religion or belief in worship, observance, practice, or teaching, either individually or in community with others, and either in public or in private. Okay. Interesting little tidbit here. I honestly don't think they do this anymore today. But the Maori tribes back during the day there, when they would go to war with someone, usually with each other, they would occasionally engage in a ritual where they would cook and eat their enemies. They were cannibals. But they did this for spiritual reasons. The idea was that if they consumed their enemy, they would consume their warrior essence, or what they called mana. And they also thought that their ancestors lived in their weapons because their weapons were generally handed down from generation to generation. And New Zealanders were well renowned for their unique approach to war. Some people may notice they did something called a Maori haka, which is their war challenge. They would stand there and dance and have this chant. I don't know all the words, obviously, but it's pretty interesting there, that little portion. Assembly. The right to peacefully assemble, Section 16. Well, that's pretty common throughout any former British colony. Association. The right to freedom of association. You can know whoever you want, and you won't be chastised for it. We are supposed to have that here in the States, but we don't. Let's face it. Anytime we associate with somebody deemed an enemy or a communist or something like that, we automatically get, quote-unquote, canceled. Well, this basically says you can't cancel anybody for that, so that's great. Movement. Okay, well, this is pretty common among British colonies, former British colonies as well. The right to freedom of movement and residence in New Zealand, Section 18.1. Okay. The Act guarantees to every New Zealand citizen the right to enter New Zealand, Section 8.2. The Act guarantees everyone the right to leave New Zealand, Section 18.3. The Act also guarantees, Section 18.4, ensures that non-New Zealand citizens lawfully in New Zealand shall not be required to leave except under a decision taken on grounds prescribed by law. We have somewhat of a similar situation here, and I honestly don't know how their people react to people who are not New Zealanders coming to their country, but I know we're not very good at it. So, but overall, they are a fairly peaceful people overall. They rank high on personal freedom and liberty. I think they're like number 2. Is it number 2 or they may even be number 1 in personal freedom and liberty in the world. I don't really know. But they're high up there. Okay, non-discrimination and minority rights. Some nerve here, really, because the minority outnumbered them like 100, like what, 300 to 1 or something like that? I don't remember exactly the number here, but the British colonists were the minority when they first arrived, and now there's something here saying in 1990 saying minorities, meaning the Maori descendants or whatever. The hubris, the arrogance of this. Anyway, non-discrimination and minority rights. Section 19 of the Act guarantees freedom from discrimination on the grounds of discrimination set out in the Human Rights Act of 1993. Section 20 provides protection for the culture, religion, and language of individuals who belong to ethnic, religious, and linguistic minorities. In other words, it's multiculturalism. So if you have a different language, you have another culture, you're from somewhere else, you can bring that with you, and New Zealanders, they can't seek reprisal or force you to be a certain way because of that. You can be who you want. So you're secure in your person. Great. All right. Okay, here's a common one. Search, arrest, and detention. The Act guarantees everyone the right to be secure against unreasonable search and seizure, whether of the person, property, or correspondence, or otherwise. Section 21. The right not to be arbitrarily arrested or detained. Section 22. Well, of course. Everyone who is arrested or who is detained has the right to be informed at the time of the arrest or detention, the reason for it, and consult and instruct a lawyer without delay, and to be informed of that right, and have the validity of the arrest or detention determined without delay by way of habeas corpus, and to be released if the arrest or detention is not lawful. This is almost word for word, if not word for word, what's in the Canadian Constitution. So yeah, there we go. I think it's pretty. If you know any former British colony, you're likely going to see the same thing. So when we get to Australia, I honestly would not be surprised to find a lot of the same language. Yeah, moving on. Everyone who is arrested for an offense has the right to be charged promptly or to be released. Okay. Everyone who is arrested or detained for any offense or suspected offense shall have the right to refrain from making any statement and to be informed of that right. Self-incrimination, right? Everyone deprived of liberty has the right to be treated with humanity and with respect for the inherent dignity of the person. Boy, if only that were true. It's not just here in the U.S., but everywhere, man. How do you police something like that to a T? I mean, it's really difficult, but it's always a good thing to have down. Criminal justice. The Act requires that everyone who is charged with an offense shall be informed promptly and in detail of the nature and cause of the charge, and shall be released on reasonable terms and conditions unless there is just cause for continued detention, and shall have the right to consult and instruct a lawyer, and shall have the right to adequate time and facilities to prepare a defense, and shall have the right, except in the case of an offense under military law tried before a military tribunal, to the benefit of a trial by jury when the penalty for the offense is or includes imprisonment for more than 3 months, and shall have the right to receive legal assistance without cost of if the interests of without cost if the interests of justice to require and the person does not have sufficient means to provide for that assistance, and let's scroll down here. Shall have the right to free assistance of an interpreter if the person cannot understand or speak the language used in court. Section 24. Fair trial. Everyone who is charged with an offense has the minimum right to a fair and public hearing by an independent and impartial court, to be tried without undue delay, to be presumed innocent until proven guilty according to law, not to be compelled to be a witness or to confess guilt, to be present at the trial and to present a defense, to examine the witnesses for the prosecution and to obtain the attendance and examination of witnesses for the defense under the same conditions as the prosecution, if convicted of an offense in respect of which the penalty has been varied between the commission of the offense and sentencing, to the benefit of the lesser penalty. Yeah, funny how we don't have that here, right? If convicted of the offense, to appeal according to the law to a higher court against the conviction or against the sentence or against both. In case of a child, to be dealt with in a manner that takes account of the child's age. Okay, so you obviously try minors and adults differently, right? There's nothing new about that. Double jeopardy, section 26. Section 26 covers instances of double jeopardy. The Act holds that no one shall be liable to conviction of any offense on account of any act or omission which did not constitute an offense by such person under the law of New Zealand at the time it occurred. No one who has been finally acquitted or convicted or part of or pardoned for an offense shall be tried or punished for it again. You know, we have different language in our Constitution, but it is what it is. Important court cases, there's remedies under the Bill of Rights, natural justice, section 27, the natural section of the Act. Section 27 of the Act guarantees everyone the right to observe the principles of natural justice by any tribunal or other public authority which has the power to make a determination with respect to a person's rights, obligations, or interests protected or recognized by law. Every person also has the right to bring civil proceedings against and to defend civil proceedings brought by the Crown, and to have those proceedings heard according to law in the same way as civil proceedings between individuals. Okay, well that's where our criminal justice system got its foundation. So there you go, same thing. And this one just goes through court cases, remedies. The Bill of Rights does not provide express remedies for the Act. This must include exclusion of evidence, reduction in sentence, cost, compensation. A lot of this declaration of inconsistencies, a lot of this has to do with their legal system. As I said before, the New Zealand Constitution is not a straight line. You know, it wasn't something that was sat down and everybody just figured it out. This is just a kind of a piecemeal collection of different treaties and different rights over time. Court decisions contribute to it. Culture plays a huge part in it as well, obviously, as it does with any constitution. But overall here, New Zealand is an ongoing experiment. You know, they're still evolving. And, you know, according to where they stand in the world right now, they're doing incredibly well. You know, New Zealand, of course, has beautiful scenery, you know, just wonderful, friendly folks, great culture to enjoy. I'd love to go there someday. I really would. But, you know, that's really all there is to offer at the moment as far as the Bill of Rights Act of 1990 that is of anything of any consequence. So it gives you the judicial overview, obviously, the establishment of elections for Parliament. They are officially a constitutional monarchy with a parliamentary democracy. It's just like the United Kingdom, just like Sweden, maybe Australia still operates the same way, although they have a prime minister too. So, you know, that's going to do it right now for the read-through of New Zealand. You know, I wish it was more eventful, a little more straightforward, but the history is really more important than the actual constitution here. Next up will be Sweden, so keep an eye out for that. I hope you all enjoyed this little tutorial on the Constitution of New Zealand, and talk to you all soon.